Welcome to the Summer 2020 Iowa Innovation Business and Law Speaker Series on innovation policy and responses to COVID-19. I'm Jason Rantanen, Professor of Law and Director of the University of Iowa Innovation Business and Law Center. Each week, we have a short talk by one of our series speakers, followed by some time for questions. Additional details are available at ibl.law.uiowa.edu. For today's talk, feel free to submit questions using the questions function in Zoom or through chat. Additional details are in chat. Today's speaker is Professor Sapna Kumar. Professor Kumar is a Law Foundation Professor of Law and co-director of the Institute for Intellectual Property and Information Law at the University of Houston Law Center. She's an expert in U.S. patent law and has written extensively about administrative and international law issues relating to patents. In 2018, she was the recipient of a Fulbright Schumann Innovation Grant, which allowed her to be in residence at the University of Strasbourg Center for International Intellectual Property Studies and the Max Planck Institute for Innovation and Competition. Her recent article, Patent Court Specialization, was published in the Iowa Law Review and raises important concerns with intellectual property law specialization of the U.S. Court of Appeals for the Federal Circuit. Today, she'll be talking about patents, pharma, and the pandemic, the subject of a new draft paper that's posted on SSRN. And with that, it's my pleasure to turn it over to Professor Kumar.
So my research project is looking at the use of compulsory licensing during the COVID-19 pandemic. And in particular, it's looking at a tool, compulsory licensing, something that we've seen developing countries use in the past to make drugs affordable, that is now being utilized by developed countries. We have developed countries such as Israel, Canada, various member states of the European Union, all looking into how compulsory licensing can be utilized to ensure an adequate drug supply for COVID-19. And we see a contrast with what the US is doing, where the US is taking a more nationalistic approach in terms of trying to buy its way to the front of the line. So the goal in my paper is to show differing approaches between the United States and other developed countries with regard to drug development and public health during the pandemic. So my talk today is going to be in 4 different parts. First of all, I'm going to give a brief overview of what is compulsory licensing and how it gets used for drugs. Second, I'm going to talk about the US approach to compulsory licensing. I'll talk about 2 statutes in the US and just sort of the general attitude that we have towards compulsory licensing. Then third, I'm going to talk about how other countries are adapting their laws in light of the pandemic. And then finally, fourth, I'm going to talk about what the US is doing and how we might fix our current approach. So what is compulsory licensing? Generally, compulsory licensing refers to a government issuing a license to a third party without the patent holder's permission. And in doing so, the government is allowing a third party to produce and provide a patented good to the government. It can also describe a situation where there's a national law that automatically shields third parties to produce infringing products for the government, like what we have in the US. But the key idea is government producing patented goods without permission of the patent holder. Now, it's important to emphasize that compulsory licensing is not free. The government must pay some form of compensation to the patent holder. In the TRIPS agreement, this is described as adequate remuneration. However, that amount of money that the patent holder is getting paid under the compulsory license is far less than what the patent holder would have made on the open market. So let me briefly talk about the TRIPS agreement. TRIPS is the big multilateral agreement governing intellectual property protection and in particular governing patent rights among various member states. And under Article 31 of TRIPS, it talks about this issue of compulsory licensing. And basically, it gives broad permission to countries to utilize compulsory licensing for public health emergencies. And this was something that was later reiterated under the Doha Declaration, that each member state has the right to determine what constitutes a national emergency, and the fact that a public health crisis can constitute a national emergency and justify the use of compulsory licensing. This Doha Declaration came out of the AIDS epidemic when countries like South Africa were issuing compulsory licenses on retroviral drugs. Now, these provisions generally were developed with an eye towards the needs of developing and least developed countries, which is what makes their use during the pandemic that much more interesting. Before I get into that, I want to briefly mention two major points of contention on compulsory licensing, which I won't have time to flesh out now, though I can talk about more in the Q&A. One point of contention is what constitutes an emergency? When can compulsory licensing be used? Countries generally agree that drug shortages count as an emergency justifying compulsory licensing. But what if the drug price puts the drug out of reach for a large percentage of a country's residents or citizens? Um, the view on this varies. I think the TRIPS agreement's quite clear that even price can be a justification for compulsory licensing. That being said, the US has a history of punishing countries using compulsory licensing merely to lower drug prices. Probably even the bigger point of contention on compulsory licensing is whether it hurts innovation. And I could spend a whole talk discussing this issue, but let me just say in short that it's very difficult to determine. People in favor, or people who are against compulsory licensing, generally point to research that shows there's this correlation between a rise in patenting in the US and a rise in economic growth. However, it's not clear that compulsory licensing undermines that relationship. And also, what studies are out there doesn't really tell us what happens if extra people are dying or becoming seriously ill that could have been prevented through the compulsory licensing of a drug, because that's going to have an economic effect as well. That's going to hurt your economy too. There are also big ethical questions within this as well. Should we let more people die because theoretically compulsory licensing could hurt innovation? So how do we deal with compulsory licensing under US law? In the US, we have two statutory provisions that deal with this. Section 1498, 28 USC 1498, has been around in some form since the early 1900s. Basically, it lets the government infringe any patent that it likes. It is super broad. The US government doesn't have to inform the patent holder. It can just infringe away. But the government is now somewhat reluctant to use this provision in the case of drugs. It used to do it all the time in the 50s and 60s. Now it's really backed away from it. The last time that Section 1498 was even threatened for a drug was during the anthrax scare during the early aughts, when the US threatened compulsory licensing to get Bayer to drop the price of Cipro. Now, I'll note that the only reason we were successful in this ploy was because Canada had actually overridden the patent and placed a domestic order for Cipro, but that's an issue I won't get into further. But beyond 1498, we do have another provision, the Bayh-Dole Act, which is codified under the Patent Act, that tells us that if the government funds research, so if a government agency funds research that later results in a patent, the agency retains something called Marchand rights, which allows it to issue a compulsory license if a license is needed to alleviate health or safety needs that are not being met by the patent assignee or licensee. And theoretically, third parties can request a compulsory license under these Marchand rights. However, as I mentioned in my slide, the Bayh-Dole Act with regard to its Marchand rights is completely toothless. People have requested Marchand rights, but they've never been granted. No agency has ever used them. It's much too long and cumbersome of a process. For example, you have to exhaust all the appeals before the compulsory license takes effect. So as a result, it's not really something that one can count on. And kind of just looking at the overarching issue of what the US's approaches to compulsory licensing, what we see is that while we do have some tools to allow compulsory licensing to happen in the US government generally does not support compulsory licensing when it comes to drug patents. The US has punished numerous countries that have rightfully exercised their compulsory licensing ability under the TRIPS agreement. This is not limited to one political party. Both Democratic and Republican administrations have done this. The best example, or the most illustrative example, is with the AIDS crisis, when the Clinton administration placed South Africa on the Special 301 watch list and denied it favorable tariff rates as retaliation for South Africa wanting to issue compulsory licenses on antiretrovirals. So we generally as a country do not support this practice. And so that puts us in an interesting position as we move into the pandemic. So again, compulsory licensing, the laws surrounding this were really developed with an eye towards developing countries. But during the pandemic, developed countries have started rethinking their ability to get their citizens life-saving drugs and vaccines. In particular, places like the European Union are beginning to realize that they're at a severe disadvantage compared to the United States when it comes to buying access to new drugs. And so what we see is a series of legislation being passed, really laying the groundwork for the day when other countries may need to utilize compulsory licensing in a very quick fashion to get drug access for citizens. I only briefly on the slide have some examples listed. I go into it in more detail, but let me just quickly go through some of these. Israel took a massive step by issuing a compulsory license for AbbVie's drug Kaletra. I say this is a huge step, even though Kaletra hasn't proven to be a very useful treatment. Israel sent a very strong message to pharmaceutical companies that developed countries can also utilize compulsory licensing to safeguard public health. And indeed, this had ripple effects where AbbVie voluntarily offered up a license to some 100 low and middle income countries. Canada, Germany, and France have all passed legislation granting their health ministers extra powers to utilize compulsory licensing. In France, they have also increased the ability of the health minister to institute price controls. And there are other examples beyond just these four countries with regard to how different countries are beginning to adapt their laws to the pandemic. And one thing that's also worth mentioning is that a lot of these other developed countries are taking a very collaborative approach. Beyond just changing their laws, they're also pooling resources with each other to develop new treatments. The European Union and other countries already have laws in place regulating prices. So, there's really a big initiative going on outside the United States in terms of facilitating the development of new treatments through a collaborative approach and through the possibility of compulsory licensing. Now, contrast that to the US. So in the US, we've adopted a practice that's been dubbed vaccine nationalism, where we've seen the Trump administration looking to buy access to any newly developed vaccine. So the way this is working is the US government has poured several $billions into foreign pharmaceutical companies as well as domestic ones. So this includes more than $1 billion that's gone to Sanofi, which is French, to CureVac, which is German, to AstraZeneca, which is a British-Swedish pharmaceutical company. And in doing this, in providing these funds, we enter into these agreements basically saying the pharmaceutical company, if it succeeds in developing a vaccine, will provide some number of doses to the US, some number of priority doses to the US. Now, it's important to note here that in brokering these agreements, there is no guarantee that, one, there'll be enough vaccines for everybody, and two, there's no guarantee that any of those vaccines will ultimately be affordable. So we have no idea what the cost will ultimately be in terms of what consumers will have to pay to receive these vaccines. And this nationalistic approach has led to a massive backlash from EU member states. When the stories broke with regard to CureVac in Germany and Sanofi in France, it led to immediate retaliation from those governments, where the executives of the pharmaceutical companies were brought in and meant to explain themselves to the government. France pointed out that they've been giving tax subsidies to Sanofi for years. And a kind of a funny quirk of all of this is it's had this unintended effect of actually unifying members of European Parliament across the political spectrum in favor of supporting compulsory licensing, such that you now have these these center-right members of parliament who are saying that if the US somehow jumps the line on access to vaccines, that the European Union should immediately put something into place to facilitate compulsory licensing. The other thing I want to say with regard to the US approach is we are now beginning to see a political split with regard to compulsory licensing. So in the beginning, like I said, and I just managed to, let me get my slides back up here. In the beginning, as I said, what we had was a situation where it was primarily both the Democrats and the Republicans who were trying to punish these countries using compulsory licensing. And what we've seen now is a beginning of a shift where there are Democrats in Congress who are more supportive of getting promises with regard to affordability of drugs, promises with regard to accessibility, in exchange for providing funds for developing new vaccines or new treatments regarding COVID-19. However, the Republicans remain opposed to this, which means that for the legislation that's recently been passed these past few months, there weren't any kinds of safeguards. So, given that's the case, what do we do in the US if we end up with a pandemic-related drug shortage? And I think this is an important question because we are already beginning to see the pandemic-related drug shortages. I'm giving this talk from Houston, where we have a number of hospitals that have run out of remdesivir, and we're also out of, or very low on COVID-19 tests. And these kinds of shortages are likely to become a bigger problem as time goes on. And it will certainly be an issue if a new vaccine gets developed. So how do we deal with this situation? So with regard to federal solutions, there's a lot that's already been said on this issue. And let me just highlight a few things. So first of all, we already have legislation that gives the government broad authority. Um, the problem that needs to be overcome is being able to force the government to use compulsory licensing. So in my paper, I'm currently, this part of this paper is currently under construction, but what I'm working on is, can we have a citizen standing provision where a third party can potentially compel the agency to grant a compulsory license? Is there a way we can pass legislation to allow courts the ability to grant the compulsory license more easily? I think these are things worth exploring. But what about in the meanwhile? And here I have a last resort state solution. And this is not a great solution, I fully admit this, but states could import drugs from countries that are disregarding patent rights. And here is how it could happen. So states have sovereign immunity, which means that you can't sue a state for patent damages without their consent. So if a state were to move quickly and quietly, it might succeed in being able to import and or distribute drugs before the patent holder notices and sues for an injunction. Now note, there are problems. Any such action would violate FDA regulations because states can't import FDA-approved drugs without FDA approval. However, FDA and customs are somewhat limited in their ability to fine states. And that's because of the language that's used in a bunch of statutes that refers to any person, and this general principle of statutory construction that a state is not a person. Not to say that FDA and customs are without recourse. They could just seize things that are imported, though if they did that, they would be risking a bit of a PR nightmare in terms of taking away drugs from states that need it. So the thing about states trying to act is this: even if the states ultimately lose in terms of the FDA comes in and seizes its drugs, in a way they may end up actually winning, because pharmaceutical companies are responsive to bad PR. And we saw this with the AIDS crisis with regard to South Africa, when people started shaming the pharmaceutical companies. And I think we would see something similar if the federal government tried to intervene with states trying to secure a drug supply for their citizens. So with that, I will end my talk, and I would welcome questions and comments from all of you.
Terrific. Thank you, Professor Kumar. So as noted in the chat, you can type your questions directly into chat and we'll be able to see them. You can also type them into the Q&A button. And I'll go ahead and read our first question out. Professor Contreras says, could a patent holder bring an ITC action to prevent the import of an infringing drug even if imported by a state? That is, does the state's sovereign immunity affect the ability of the patentee to seek relief at the ITC? The surefire way for a state to operate in this sphere might be to manufacture the drug under the auspices of the state.
So this is a great question. I've looked at Title 19, and it's really interesting because most of Title 19 is written with regard to any person. And the definitions section of Title 19 does not include states within the definition of a person. So for example, you can't bring an action directly against the state. What you could do in the ITC is bring an action against the pharmaceutical company that the state has contracted with. Now, so what is that going to get you? The ITC would be able to seize the shipments via customs. They would not be able to fine the state. So it's somewhat, the result is you end up with something that's somewhat limited, right? If a state were to act quickly, like what Illinois did under cover of darkness, where they had the charter plane go to China and then come back with masks in the middle of the night, if you had a state pull that with drugs, I don't think the ITC would be able to really act in time to do anything, nor would any of those fines that Customs usually has the ability to levy be applicable at the state level, because under Title 19, as far as I can tell, Customs can't actually fine a state. Now, again, all of this would premise that you're getting your drugs from someone that does not have enough contacts with the US to be able to be brought in as a contributory infringer.
Right. I have a related question. This is from Bob Koch-Deegan. And what about tribal authority to import drugs?
Ooh, that could be really interesting. So I would have to actually look into this in terms of whether tribal sovereign immunity would give some powers. Now, obviously, we have the Supreme Court decision telling us that you can't just transfer your patents to a tribe to get around inter partes review. But I'm not sure that you could levy any kind of fines on a tribal government either. And that's actually super interesting in terms of you might be able to find a tribal government that's willing to go about this, given how bad the situation is on some of the reservations with COVID-19. I'll have to look into that, Bob. Thank you.
Okay, this is from Bob and Sampat. Does CL really work for vaccines? I think compulsory licensing really work for vaccines, where one needs not just or even mainly the patent, but also transfer of know-how for scale up.
That is a great point. So you are absolutely right that there is going to be a lot of trickiness with regard to whether there's adequate know-how such that even if a government grants the compulsory license, will it be able to manufacture the vaccine, or will it lose so much time trying to replicate that it won't be useful? And that is a weak spot in my argument in terms of both with vaccines and with some of these really high level biologic type drugs. They can be very difficult to produce. And unfortunately, let me say this. The compulsory licensing in that regard might fail in terms of, even if the compulsory license is issued, the state can't replicate, or the country can't replicate the vaccine. However, just the act of issuing the compulsory license often spurs the pharmaceutical company to magically get more realistic on its pricing. We've seen that in the past. So my hope would be in that circumstance that just the declaration that we're going to grant the compulsory license would be enough to make the drug price come down. But it's a very good point.
I have another one from George. I've been told that Cholestra is off patent in the US and most of the world, and that Israel is an odd case where the patent continues. This, of course, makes AbbVie's subsequent commitment not to enforce the Cholestra patents, Kaletra patents somewhat hollow. Do you know if this is accurate?
So I'm not actually so the short answer is no. I'm not certain about that one way or the other. I know that there were certain countries that did not have patents on it, though they did later then list 100 countries claiming they were granting a voluntary license to them. It very well could be a hollow action. Yeah, I apologize. I don't have more information than you do on that.
All right, so we are unfortunately out of time. So thank you for sharing your expertise on this subject with us, Professor Kumar. Join us next week where Professor Rachel Sachs, Washington University in St. Louis, will be talking about reimbursement policy and COVID-19 innovation. So I hope to see you all then.
Thank
Bye-bye.
you.